My name is Andreas Liewald. I'm an attorney with the Illinois Guardianship and Advocacy Commission. Since 1979, the Commission has advocated for the rights of persons with disabilities. As a member of the Illinois State Bar Association's Mental Health Law Section Council, I'm here to talk to you about whether guardianship may be appropriate for a person diagnosed with a mental illness. It's very likely that an attorney will be approached by someone considering guardianship for an adult family member or friend who has been diagnosed with a mental illness. Given the definition of disabled person under the Illinois Probate Act explicitly includes persons diagnosed with a mental illness, it's not surprising that many people think that guardianship is an appropriate intervention. But in Illinois, guardianship has its limits, and that's true when a guardian is seeking mental health treatment for a ward. In the next few minutes, I would like to talk to you about the limits of guardianship, when guardianship may be useful, factors to consider whether to pursue guardianship, and finally, alternatives to guardianship for someone diagnosed with a mental illness. Illinois limits a guardian's authority to consent to mental health treatment. Let me give you 3 examples of these limits. First, a guardian may not consent to a ward's admission to a psychiatric hospital or mental health unit. In other words, if a patient is brought to a hospital for mental health treatment, the patient can only be admitted if he or she completes an application for voluntary admission, or if a petition for involuntary admission and certificate are completed. A guardian cannot consent to the voluntary admission of a ward unless the ward requests a guardian to do so and the ward has specific capacity to consent to that admission. Second, a guardian in Illinois may not consent for the involuntary confinement of a ward in a nursing home when the main purpose is for psychiatric treatment. Finally, a guardian may not consent over a ward's objection to psychotropic medication or electroconvulsive therapy, which is also known as ECT. In Illinois, a person may only receive involuntary mental health treatment under the authority of the Mental Health and Developmental Disabilities Code. This means if a ward is objecting to mental health placement or treatment, a petition for involuntary admission or involuntary treatment would have to be filed with the circuit court, and the ward would be entitled to a full hearing. Although there are limitations on what a guardian may consent to for a person diagnosed with a mental illness, there are times when guardianship may be appropriate. Here are 4 examples. First, guardianship may be appropriate if the ward is unable to make reasoned decisions about medical treatment, especially life-threatening conditions. For example, a ward may not acknowledge or comprehend the need for medical treatment, or a ward needs consent to be admitted to a hospital for a medical condition. Second, guardianship may be appropriate to manage finances or apply for benefits if the ward is unable to do so. Third, guardianship may be appropriate if a guardian wishes to obtain information and progress about the ward's mental health treatment and placement. Finally, guardianship may be appropriate if the ward is not objecting to psychotropic medication or ECT. The guardian may then consent. For example, if a ward is suffering symptoms of catatonia or depression and is nonverbal, the guardian may consent to mental health treatment. Guardianship is the most restrictive option to a person in need of help. Guardianship always means the court involvement with the likelihood of a public examination of one's private affairs. Don't forget that there are costs associated with litigation and ongoing compliance with court directives and supervision. Court involvement and litigation will also take an emotional toll and impact relationships. All possible alternatives should be explored before initiating guardianship proceedings. which means use your resources. Competent medical and legal professionals, social workers, caretakers, family, and friends should be consulted whenever possible. After all this, we have other options. Here are alternatives to guardianship: the use of payeeships, financial counseling, bill-paying assistance programs, living trusts, in-home support programs, outpatient social services and treatment programs, and other advocacy services may avoid the need for guardianship. Illinois law also provides two alternative means of making decisions for a person in need of mental health treatment, offering both a power of attorney and declaration for mental health treatment. These are advance directives that designate another person to make decisions on someone's behalf. Like guardianship, a power of attorney may make medical, personal, and financial decisions. In addition, it may allow for the agent to make mental health treatment decisions. By signing a power of attorney, the person is able to detail specific things he or she wishes an agent to consent to. For solely mental health treatment, a declaration for mental health treatment may be the most effective. Like a conventional power of attorney, a declaration for mental health treatment is intended to give the principal the ability to determine what will happen in the event the person is incapacitated. It's very important to note that unlike a conventional power of attorney, a declaration for mental health treatment may not be revoked unless a physician states in writing. To the client's benefit, advance directives, both the power of attorney and declaration for mental health treatment, allows persons to customize documents to reflect personal preferences. The execution of such documents requires no court involvement, and these forms are readily available. Another possibility for a person who episodically is unable to make mental health decisions is for an assisted outpatient treatment court order under the Mental Health and Developmental Disabilities Code. Finally, if guardianship is needed in order to promote personal autonomy, one should consider the least restrictive form of guardianship. This means limited guardianship as opposed to full or plenary guardianship. For example, if a person is unable to make financial decisions, but is able to make medical decisions, the guardianship order should be limited to finances. I hope that this video was helpful in beginning the dialogue about whether guardianship is appropriate for a person diagnosed with a mental illness. If you have questions about whether guardianship is appropriate, you may contact the Illinois Guardianship and Advocacy Commission toll-free at 866-274-8023 and speak to a knowledgeable intake worker. The intake worker may answer your questions about guardianship and alternatives and may provide you with referrals. You may also visit the Illinois Guardianship and Advocacy Commission's website. Mental illness affects everyone. It's challenging to find solutions to best help address the needs of a person diagnosed with a mental illness who is unable to make decisions. Remember, guardianship has its limits, and it's not the only option. There are alternatives, and together we can find them. To learn more about the benefits of joining our ISBA Mental Health Law section, please visit the ISBA website.